Hello, and welcome to the Arbitration Conversation. So in this conversation, we're going to speak with a leading arbitrator, a leading expert practitioner in the world of international dispute resolution. Today, we have Stephen Anway. He is a partner with Squire Patton Boggs, and he actually co-chairs the firm's international dispute resolution practice. He's been listed in November 2020, Law 360 recognized the group as International Arbitration Practice of the Year, which is huge. So Stephen, I know you're extremely busy and you have offices in Washington, D.C., New York. You're constantly traveling, but of course the pandemic has put a bit of a damper on that. But I really appreciate your taking the time to talk with us today about international dispute resolution.
Thank you, Amy. I'm happy to be here.
So first of all, I guess I always really love hearing how does a person become the co-chair of this mammoth group in international dispute resolution? You know, a lot of students might be listening and thinking, how could I ever become a partner working in this area of international dispute resolution?
Well, my path to international arbitration, I think like most of my colleagues who are my generation or older, came into international arbitration not as sort of a planned end goal. When I went to law school 20 years ago or so, not many law schools were teaching international arbitration. Not many students were aware of the field. The investment treaty practice globally really had yet to take off. It didn't start until the early 2000s. And so I got involved just as that practice was really starting to grow. And I was a summer associate here at Squire. The firm was then called Squire, Sanders and Dempsey. It's now called Squire Patton Boggs. After my first year of law school, as a summer associate, I came back as a second year summer associate after my second year of law school, and did a 2-year clerkship after I graduated from law school, but had accepted a full-time offer with the firm and returned to the firm as I promised I would at the conclusion of the clerkship. And I was put into a litigation practice. And after spending 2 or 3 months in that litigation practice, the head of the newly minted international dispute resolution practice at the law firm, a mentor and a friend named George Von Muren, who now is my co-chair of the IDR group here at the firm, came walking down to my office. We had a wonderful partner named Ricky Gerbst, who used to come around to everyone's office to make sure they had enough work, but not too much. And I said something to Ricky that I have never said in my life since, which was, Ricky, I could use a little more work. And he then sent George down to my office. George was already a famous lawyer. His father, Arthur Von Muren, was one of the deans of international arbitration. He had taught international arbitration at Harvard Law School for 40 years. George is his eldest son and was already a very well-known lawyer in this field at the time. So when he came to my door, it was somewhat intimidating. And he said to me, I understand you just finished a clerkship for a judge that George knew very well and respected. And he said, I hope you can put a few words together. And I said, I hope I could. So he asked me down to his office, and he was dealing with the very first natural gas price review arbitration in history. And these cases, as a collection of cases, are perhaps the largest disputes in the world, just in terms of the monetary value. And he told me that there was a very significant Wall Street firm with an army of lawyers on the other side. And he turned to me and said, you're my army. So he had a partner from our Madrid office down in his office who had come over from Spain. And they needed a common law lawyer to understand the intricacies of the European natural gas markets and the liberalization of those markets, and how it impacted a very complicated pricing formula. And for the next, 5 or 6 hours, I sat in on the meeting. It was the most complicated material I had ever heard. I remember thinking to myself, I'm going to go back to my office, shut the door, and try to master this material over the course of the next week, hope to come back and ask a few questions. And I then looked at George, who said to me, I'm going to need a draft by 5 p.m. tonight. So I went back to the office, shut the door, called my wife and said, I don't think I'm going to be working here much longer. I was convinced that my career at the firm was going to be somewhat short-lived as a result of this. I ended up seeing George in the hallway shortly before 5 p.m. He said he had just returned from Europe. He'd be getting up early because he was still on European time, and it was okay if I sent that draft by 5 a.m. And so I sent it at 4:59 a.m. I got in the car, drove home, woke up 30 minutes later to an email that said, "This looks good. Come back into the office when you can and let's keep going." And that started my career in international arbitration. I moved to the IDR group almost immediately after that, and I've been working with George effectively ever since.
Wow, that's a great story. Well, and I guess, as you go along and you think about, as you're saying, investment treaty arbitration, of course, is huge in international arbitration. I'm sure you deal with a lot of those issues. Are there any trends that you have been seeing in that area of investment treaty international arbitration?
Yeah, I think the clearer trends we're seeing are in investment treaty arbitration. The most significant, of course, is the reform of the system, particularly the reform that's being sought by the European Commission and the European Union more generally. And this was accelerated, of course, by the 2018 decision from the Court of Justice of the European Union in the famous Achmea versus Slovakia decision. Slovakia has been a client of mine for the last 9 years, 10 years. And one of the positions that Slovakia continued to take, even when all the arbitral tribunals were rejecting the argument, was that intra-EU bilateral investment treaties, so these are bilateral investment treaties between two EU member states, were invalid and contradicted some of the founding treaties of the European Union. And notwithstanding the fact that virtually all the tribunals had rejected this argument, indeed there wasn't even a dissenting arbitrator that had ever agreed with it, the Slovak Republic continued to press the issue, as did some other countries, including the Czech Republic and later Spain and Croatia and others, Romania most recently. And what the Slovak Republic did that was unique in this case, this is the Achmea 1 case where I did not represent them. I ended up representing them in the Achmea 2 case where we won on a different jurisdictional ground. But in the Achmea 1 case, back in 2008, 2009, at the beginning of the case, the Slovak Republic researched which seats of arbitration in the European Union were most likely to have their national courts refer questions of EU law to the European Court of Justice. And the idea was that if the arbitral tribunals would not agree with the Slovak Republic on this jurisdictional objection, perhaps a European court might. But of course, the arbitral tribunals don't have the ability to refer questions of EU law to the Court of Justice. Only the national courts in the European Union do. And as a result of that research, at the very beginning of the case, they planted a seed that years later would bear fruit. And it was the identification of Germany as the country in which its national courts most often referred questions of EU law to the Court of Justice. And so the Slovak Republic convinced the arbitral tribunal in that case to seat the case in Frankfurt. And when the Slovak Republic lost on the merits in the arbitral award, they sought to set it aside at the seat, which is the only place you can seek to set aside an award. And not the first instance German court, but the second instance German court, in fact, agreed to refer this question of EU law to the Court of Justice of the European Union. And on a fateful day in 2018, much to the surprise of everyone, because even the Advocate General had advised the court to reject this argument, a 15-member grand chamber session of the European Court of Justice unanimously accepted the Slovak Republic's argument and held that these arbitration clauses in intra-EU BITs are invalid. And it therefore raised questions whether all of these arbitral tribunals had jurisdiction to decide any of these claims. It was a fateful day for me because I was sitting in Washington, D.C., preparing for an ICSID proceeding that started the next day, in which I represented a different European Union country. And we had raised the Achmea jurisdiction. Now, there were many lawyers at the time that had not raised that issue because it had been so roundly rejected by all the tribunals. But in that case, we had raised it. And as you might imagine, my opening statement was significantly changed just the day before I was about to give it. Now, what has happened since then is that the arbitral community has found ways to distinguish the Court of Justice's decision. And so notwithstanding the Court of Justice's decision, all the arbitral tribunals that have taken up the issue of whether the ACMEA 1 decision means they have no jurisdiction have rejected that argument and nonetheless exercised jurisdiction. So the arbitrations are still going on, but a separate issue is enforcement. Because even though the arbitral tribunals may not feel themselves bound by the ACMEA decision, it's a separate question of whether the national courts of the countries that are being sued will recognize that decision, since they are members of EU states, of the European Union. The states are members. And therefore, that issue is one that I think is causing some reduction in the number of claims that are being filed in the European Union. And it's also, to come to your question, I think accelerated the European Union's desire to effectively revamp the system and create some type of investment treaty court within the European Union. That's probably the most significant trend we're seeing. Now, there are other trends. For example, following the Mauritius Convention and its signing and ratification by so many countries several years ago, I think you're seeing more and more transparency in investment treaty arbitration. I handled a case for the Slovak Republic several years ago called Eurogas, and it was a case involving two BITs, one Slovak Canadian, the other Slovak, the United States, and the Canadian one had a transparency protocol on it, which was a new legal instrument that had recently been attached to that treaty, which required that the proceedings be conducted entirely open to the public. And to ensure that the witness sequestration rules were still respected, what this has meant in practice is that the hearings are videotaped and that there's some delay before they're put online, so that way witnesses that are sequestered can't view what's going on in real time. But what you see is the entire video of the proceedings being posted online, and of course, all of the briefs, and in some cases, even expert reports, witness statements, and exhibits also being made available. So I think we're seeing more and more transparency in investment treaty arbitration as well.
Wow, yeah, no, those are big trends. I'm wondering, sort of going back to this reform, when do you think we'll see this creation of this investment treaty court, if you will, in the EU? Has there been sort of the latest developments there, and when you think maybe reform will happen?
Yeah, I think it's still a little bit of a ways off. I would not expect anything in the next 6 months or so, but I think in the coming years we probably will see something more formal. But there's been so much debate over the years about what it will look like and how, for example, judges to this court will be appointed. If they're only to be appointed, for example, by the states themselves, many foreign investor representatives have wondered whether the foreign investors will have the same type of fairness that they have perceived to have in the past, where they've been able to appoint an arbitrator of their own. So much of this is going to come down to the detail in terms of how the decision makers are ultimately going to be appointed, and the pool of judges or arbitrators, whether they'll be rotating, whether they'll be permanent. I think all of these things are what is going to make this such a delicate issue, and one that's going to take some time to iron out.
Oh, yeah, I would imagine. Well, and of course, there's also the question of how does this apply if, for example, one of the parties is within the EU, but then you have the other party is not, in terms of disputes. I mean, do you have the same issue in terms of enforceability, or have you not seen that?
If it follows from the ACMEA decision, there is no prohibition to enforcement even within the European Union, because the ACMEA decision was only applying between intra-EU BITs. So for example, in the case I just gave, where you have a Canadian investor that's suing an EU member state, the ACMEA decision in principle wouldn't apply. And so the question then will be, when this reform happens, is the reform going to be limited to just the intra-EU context, or whether it would be also applicable to cases that involve foreign investors from outside the European Union? And again, something I think we'll have to see as they continue to try to iron this out.
Yeah, no, that's interesting and definitely development to be following. Also on the transparency, that's really interesting. I imagine that there's a lot of questions though, as to, for example, in some cases where they might have a reason why they do not want to disclose particular information to the public for different business secrets or other issues of those kind. Have you seen issues with protecting and protection orders?
Yeah, we have. And the way that the tribunals have been dealing with those issues is generally to allow some period of time before any of the information goes public. I noted, for example, the delay in the release of the videotape online, but the same principle would apply to any written documents as well. And the idea is that whatever document that is submitted or video that is taken, you then provide the parties some period of time, and it can often be as much as a month, to go through both the documents or the videotape to ensure that if there are matters that are particularly sensitive, whether they're business secrets, whether it's personal data that should not be released to the public, that the parties have an opportunity to redact them.
Yeah, that's important.
Yeah.
Well, and I guess, one final question. Have you seen, because a lot of times, we're talking about cases with millions of dollars at stake. They're very important cases. Parties might really want them to be in person. Have you seen proceedings go ahead with in-person hearings even during the pandemic, or have you seen more virtual hearings being used?
Far more virtual hearings being used. I will tell you that in 2020, and not just my own practice, but the entire IDR group here at the firm had 20 or 30 different hearings that were rescheduled and postponed until 2021 with the hopes that the pandemic would subside and it would be safe enough to be able to do them in person. I think all of us prefer the in-person hearings. My own sense was when the pandemic first hit and so much more, not just in terms of hearings, but also client meetings started to be done by video, there was a sense that this really was going to be the wave of the future, even after the pandemic subsided. My own view of it, and I think many have come to this view, is as we've continued to do this by video for almost a year now, people are pretty anxious to get back into a room where they can be in person. I think presentations to tribunals are very different when you're in person. Certainly cross-examinations are much different when you're in person. And even sitting down with your client to work through the evidence, to work through the memorials, to work through the witness statements, all of those things are far easier in person. But we're still seeing that the vast majority of hearings are done virtually. I am aware of many that are being done in person, but they tend to be ones where, for example, we have partners who are based in Europe and opposing counsels in Europe, and the arbitrators are in Europe, and you don't have sort of the challenges with coming over to the United States or going over to Asia or the Middle East, and the entry problems you would have because of the pandemic. So we are having some in-person hearings, but far more virtual, and I would say far more virtual even if one of the parties is demanding that the hearing be held in person. Tribunals, I think, were willing initially to postpone the hearing to 2021, but at this point, my sense is that tribunals are getting a little impatient in terms of allowing the case to just linger for long periods of time where there's no activity in the case, simply so that we can ensure there is a physical hearing. They're effectively ordering the virtual hearings, even if one of the parties is showing a strong preference to do it in person.
Yeah, no, it's interesting. I'm hearing the same thing from other arbitrators. So, but I think it's interesting to sort of watch how this develops and your view, that you miss the in-person aspect, which of course is something that hopefully will come back in due time, right?
Exactly.
Well, listen, I really appreciate your taking the time. I promise not to take up too much. I think really great developments, things for us to watch. That was really informative and helpful. So I appreciate it.
Great. Thank you, Amy. It was a pleasure.